Good evening friends, you are most welcome to Think Eyes channel. Today we are going to discuss second ARC report, Administrative Reforms Committee report. It is the first report of second ARC. Here we will discuss right to information. Summary of recommendation on right to information, master key to good governance. Let us begin the topic with introduction part. Right to information has been seen as the key to strengthening participatory democracy and ushering in people-centered governance. Access to information can empower the poor and the weaker section of society to demand and get information about public policies and actions, thereby leading to their welfare. In a fundamental sense, right to information is the necessity for good governance. Recommendations on Official Secret Act. There are two clauses. First is the Official Secret Act 1923 should be repealed and substituted by a chapter in the National Security Act containing provisions relating to official secrets. Second is the Suri Committee recommended a comprehensive amendment of Section 5 Clause 1 to make the penal provisions of OSA Official Secret Act applicable only to violations affecting national security. Next heading is governmental privilege in evidence. Section 123 of the Indian Evidence Act 1872 should be amended. Section 123 of the Indian Evidence Act 1872 should be amended. Accordingly, the following will have to be inserted at the appropriate place in the Code of Civil Procedure 1908 and the Code of Criminal Procedure 1973. Any person aggrieved by the decision of any court subordinate to the High Court rejecting a claim for privilege made under the Section 123 of the Indian Evidence Act 1872 shall have a right to appeal to the High Court against such decisions in such appeal, and such appeal may be filed notwithstanding the fact that the proceedings in which the decision was pronounced by the court is still pending. Next heading is the oath of secrecy. As an affirmation of the importance of transparency in the public affairs, Minister on assumption of office may take an oath of transparency along with the oath of office, and the requirement of administering the oath of secrecy should be dispensed with. Article 75 Clause 4 and Article 164 Clause 3 and the third schedule should be suitably amended. Safeguard against disclosure of information against the national interest may be provided through written undertaking by incorporation of a clause in national security law dealing with official secrets. Exempted organizations. First is the armed forces should be included in the second schedule of the Act, since public interest in disclosure outweighs the harm to the protected interest. By including armed forces in the second schedule, while national security is safeguarded, disclosure is still mandatory when public interest demands it. Second is the second schedule of the Act, which contains exempted organizations, may be reviewed periodically. Third is all organizations listed in the second schedule have to appoint PIOs. Appeal against orders of PIOs should lie with Central Information Commission (CIC), State Information Commissions (SICs). This provision can be made by way of removal of difficulties under Section 30. Next is the Central Civil Services Conduct Rules. This is important. The Commission agrees with the views of the Suri Committee. The Central Civil Services Conduct Rules were formulated when the RTI Act didn't exist. The spirit of these rules is to hold back information. With the emergence of an era of freedom of information, these rules would have to be recast so that dissemination of information is the rule and holding back information is an exception. Next heading is Implementation of the Right to Information Act. Section 12 of the Act may be amended to constitute the selection committee of CIC with the Prime Minister, Leader of Opposition, and the Chief Justice of India, CJI. Section 15 may be similarly amended to constitute the selection committee at the state level with the Chief Minister, Leader of Opposition, and Chief Justice of High Court. Designating information officers and appellate authorities. All ministries, departments, agencies, offices with more than one PIO have to designate a nodal assistant public information officer with the authority to receive requests for information on behalf of all PIOs. Such a provision should be incorporated in the rules by appropriate governments. PIOs in central secretariats should be of the level of at least deputy secretary or director. In state secretariats, officers of similar rank should be notified as PIOs. In all subordinate agencies and departments, officers sufficiently senior in rank and yet accessible to public may be designated as PIOs. All public authorities may be advised by the Government of India that along with the public information officers PIOs, they should also designate the appellate authority and publish both together. The designation and notification of appellate authorities for each public authority may be made either under rules or by invoking section 30 of Act. Recommendations on organizing information and record keeping. First is suo motu disclosures should also be available in the form of printed, priced publication in the official language, revised periodically at least once a year. Such a publication should be available for reference free of charge. In respect of electronic disclosures, NIC, National Information Commission, should provide a single portal through which disclosures of all public authorities under appropriate governments could be accessed to facilitate easy availability of information. Public records offices should be established as an independent authority in Government of India and all state within 6 months by integrating and restructuring the multiple agencies currently involved in record keeping. This office this office will be a repository to technical and professional expertise in management of public records. It will be responsible for supervision, monitoring, control and inspection of record keeping in all public offices. Third is, as a one-time measure, Government of India may create a land records modernization fund for survey and updation of all land records. As a one-time measure, Government of India may create a land record modernization fund for survey and updation of all land records. The quantum of assistance for each state would be based on an assessment of the field situation. Recommendation on capacity building and awareness generation. First is, training programs should not be confined to merely PIOs and APIOs. All government functionaries should be imparted at least one day training on right to information within a year. These training programs have to be organized in a decentralized manner in every block. A cascading model could be adopted with a batch of master trainers in each district. Second is, the CIC and the SICs may issue guidelines for the benefit of public authorities and public officials in particular and public in general about key concepts in the Act and approach to be taken in response to information requests on the lines of the awareness guidance series. Recommendation on monitoring mechanisms. First is, the CIC and the SIC may be entrusted with the task of monitoring effective implementation of the Right to Information Act in all public authorities. An appropriate provision could be made under Section 30 by way of removal of difficulties. Second is, as a large number of public authorities exist at regional, state, district and sub-district level, a nodal officer should be identified wherever necessary by the appropriate monitoring authority, CIC or SIC, to monitor implementation of the Act. Third is, Each public authority should be responsible for compliance of provisions of the Act in its own office as well as that of the subordinate public authorities. Fourth is a National Coordination Committee (NCC) may be set up under the chairpersonship or chairmanship of the Chief Information Commissioner with the nodal union ministry and SICs and representatives of state as members. A provision to this effect may be made under Section 30 of the Act by way of removing difficulties. The National Coordination Committee would serve as a national platform for effective implementation of the Act, document and disseminate best practices in India and elsewhere, monitor the creation and functioning of the National Portal for Right to Information (RTI), review the rules and executive orders issued by appropriate governments under the Act, carry out impact evaluation of the implementation of the Act, perform such other relevant functions as may be deemed necessary. Next heading is recommendation on issues in implementation. In addition to the existing modes of payment, appropriate government should amend the rules to include payment through postal orders. State may be required to frame rules regarding application fee which are in harmony with the central rules. It needs to be ensured that the fee itself does not become a disincentive. Appropriate governments may restructure the fees, including additional fees, in multiple of rupee 5. Example, instead of prescribing a fee of rupee 2 per additional page, it may be desirable to have a fee of rupee 5 for every 3 pages or part thereof. State governments may issue appropriate stamps in suitable denominations as a mode of payments of fees. Such stamps would be used for making applications before public authorities coming within the purview of state governments, as all the post offices in the country have already been authorized to function as APIOs on behalf of union ministries or departments. They may also be authorized to collect the fees in cash and forward a receipt along with the application. Next heading is inventory.